Thank you, Professor Frost. Each member will have 5 minutes to ask, and I'd like to start with you, Professor Frost. It's been stated, I'll say as a preface, that the reason for this hearing is that so many of us are unhappy with the decisions of the Supreme Court. I might state again for the record that my concern about ethical standards at the court predate this hearing by many years. In fact, 11 years. The first letter that I authored, which was signed by several colleagues on the subject to the Supreme Court, was mailed on February 13th, 2012. The president at the time, Barack Obama. So I wasn't waiting for this situation or any court decision to be interested in this issue. I think it was timely then and still is today. The second thing is the argument that we're out to get certain justices because they don't rule as we wish. I would have to say during the course of the public inquiry involving Justice Thomas and others, I've heard virtually every justice named with some question as to their conduct and activity. Now, some will say they were harmless activities and shouldn't be, no one should be punished for them, and they certainly wouldn't meet any high ethical standards. But I would just add that those of us who are in public service and bound by ethical standards and codes of ethics are certainly used to this experience. Every year when we file our financial disclosure forms, in my case, my income tax returns, I'm bound to have questions from the press, and I hope most of them are considered innocent but legitimate inquiries of a person in public service. Professor Frost, a man who submitted a letter for the record today, Judge Ludig, said of the issues that are before us, I quote him, "In complete agreement on Congress's indisputable constitutional power to legislate ethical standards of conduct that would be binding as to the non-judicial conduct and activities of the Supreme Court." You've heard arguments otherwise. I think page 12 of your testimony, which goes into one of the first acts of Congress, the Judiciary Act, belies this argument that somehow the Supreme Court is at a level where Congress can't address it. Would you comment on that?
Yes, and I'll also just note that I have been called to testify on this issue since 2006 and been writing about it since 2005. So similarly to your point, this is not a new issue in response to recent decisions. So the separation of powers argument, I find confuses me because, of course, I think we all know from civics classes, separation of powers is, of course, a constitutional principle, which means that the branches should have some separate spheres of conduct and some separate roles in our Constitution. But checks and balances is equally important. And the role of the Congress is to establish the Supreme Court. It's not just permitted, it's required. The Supreme Court of the United States is constitutionally mandated under Article 3, but there is no detail about how it is to operate because that was left to the Congress of the United States under Article 1, Section 8, the Necessary and Proper Clause. And immediately Congress agreed to do that in the Judiciary Act of 1789, as it was required to do. The Congress sets the size of the Supreme Court. That is not in the hands of Chief Justice Roberts and his colleagues. Congress establishes the quorum requirement. That is not in the hands of Chief Justice Roberts and his colleagues. When this Congress passes a law that says that they must recuse themselves, the judges and justices of our federal judiciary, when there are certain conflicts of interest, the justices are not free to say, that law doesn't apply to me, I'm going to sit on that case anyway. And so what is troubling is there is an implication in the recent statement of policy, of ethics policies, as well as some previous statements by the court, that it doesn't think these laws bind it. And I find that very confusing in light of the text structure and long history of congressional administration of the courts.
Thank you. Judge McCasey, I'd like for you to address one issue. It appears to me that in the early days of our republic, an oath had a different meaning than it does today in this respect. It is, in the swearing in of members of Congress, for example, kind of a pro forma exercise. It would seem the words of an oath in the early days of the republic were taken much more seriously, so that when the Congress set out the oath for members of the Supreme Court, every judge and justice, quote, solemnly swear or affirm I will administer justice without respect to persons and do equal right of the poor and to the rich, and I will faithfully and impartially discharge and perform all of the duties incumbent on me. Those words were written not by the court, but by the Congress, enacted by the Congress. Don't you think that raises a question as to whether or not there is clear authority for Congress to put together laws that are as specific as this oath of office?
Respectfully, no, I don't. Prescribing the oath, which I recall taking when I became a district judge, is one thing. Prescribing the way in which the court administers its business and the way in which a court applies rules internally is something else. Part of the problem here is that no rule determines its own application. It always takes somebody to apply it, and the way the court functions internally is a matter to be left to the court. In particular, on recusal issues, the law that applies to recusal issues across the board for federal courts applies to Supreme Court justices as well. When their impartiality might reasonably be called into question, they're obligated to recuse themselves. That applies to district judges, it applies to circuit judges, it applies to Supreme Court justices. That is a law of general application throughout the judiciary. But when we're talking about internal administration in dealing with their practices and the way they administer their cases, I think that's an entirely different thing. So I recall taking the oath, but I don't think it means that Congress has the power to direct that the internal business of the Supreme Court be conducted in a particular way.
Thank you. Senator Graham.